Davis School of Law. And it's my great pleasure today to introduce Tani Cantil-Sakauye, the President and CEO of the Public Policy Institute of California and former Chief Justice of California. Let's give a round of applause. Chief Justice is a proud graduate of UC Davis School of Law and earned her undergraduate degree from UC Davis as well. She was sworn in as Chief Justice in January 2011, and she was the first Filipina American and second woman to serve as Chief Justice of California. Before elevation to the California Supreme Court, Chief Justice served for more than 20 years on California appellate and trial courts. She retired from the court just this year to lead the PPIC. During her tenure as Chief Justice, she raised awareness about the unfair financial impact of fines, fees, and the bail system on the poor. She made King Hall proud when she wrote an open letter to the Trump administration expressing her opposition to immigration enforcement agents at the state courthouses. I have to say I was especially pleased when she wrote a unanimous opinion for the California Supreme Court allowing Seher Garcia, an undocumented immigrant, to be licensed to practice law in California. The daughter of farm workers, Chief Justice Cantil-Sakauye, graduated from McClatchy High School in Sacramento, attended UC Davis, as I mentioned, and she's been a longtime supporter of UC Davis. Her daughter graduated from UC Davis. Her niece was a UC Davis Law class of 2018 graduate. And among many other things, the Chief Justice has personally mentored our students as externs on the California Supreme Court. We're also very lucky to have her deliver commencement addresses in not 1 year, but 2 years, 2011 and 2018. Now we'll have a conversation with the Chief Justice and Executive Director of Marketing and Communications, Kelly Weiss. Then there'll be time for questions and audience contributions. Turn it over to you.
Thank you, Dean. Thank you, and like Dean Johnson said, we'll get started here. So as we're looking back at 12 years on the Supreme Court, quite a tenure, can you tell us about some of your accomplishments?
Thank you, and it's a pleasure to be here. I come onto the Davis campus and I come into King Hall and I feel like 30 years ago coming in and feeling warm and welcome, and I'm so proud of this school and to be here with all of you and my colleagues from my former 3rd District Court of Appeal as well, and my husband, who's also a Davis grad. But I have to say that I'm most proud of those 12 years for 2 reasons, and the first is that in a time of significant turmoil in the judiciary as a result of the continuing Great Recession, and courts closing, and people losing jobs and furloughs, and trying to keep courts open because people are at their most vulnerable in an economic crisis, and there's so much advantage being taken of these people that we were trying as a court, and the business of the court, just trying to stay open. But there was a lot of conflict among the courts and concern about what courts could be open, and at that point, too, the formula for funding courts had been disparate. So some courts were better off financially and had greater services and access than others. And so I think I was really happiest, and I think what we did together as a judiciary with the lawyers as well as the judges and the professional staff was we came together. I traveled up and down the state with justices and lawyers and professional staff, and I really asked for meetings with the private bars, the affinity bars, and the courts across the state for the first time to meet with them to say, this is our budget. We have to have a sustainable budget. It's not for ourselves. It's about access to justice. It's about making sure we stay open, and I need your advocacy in the Capitol. I'm in the Capitol, but I need the lawyers who donate, who contribute, who are part of the campaign and know members of the legislature, know the governor also, who can join in this unified message about sustainable funding for justice. And so we really came together, and across the board, I traveled thousands of miles in my first year as Chief Justice, out of a suitcase, finding myself in a courtroom, finding myself at a bar association, speaking about the future and your role and your court is in jeopardy. And if you don't speak up, the judges can't do this alone, and the legislature doesn't fully understand this. So it was coalition building. And then once we built a coalition, I was really proud that because we knew each other and we had so many voices together, we could talk through the best ways forward. And so there were so many good ideas out there at the time that I had to think of a framework about engineer all of these ideas. So we came up with the phrase access to justice, which you hear every day, ATJ, access to justice. But let me tell you, 12 years ago, people were not saying that. I don't know what they were saying, so I called it access to justice, and I called it 3D access to justice, three-dimensional access. That is physical access through courthouses, keeping courts open, keeping service windows open, building courthouses, making them ADA and LEED accessible, about making sure that we had a list of critical courts that were falling down on seismic, on quake centers where we could start to build them, where people needed to go. That was physical access. But then I thought we need remote access. We have to move in the future. We're building for you all. You're not going to want to come to court and pull out a pad and a piece of paper and a pen. We need to start building for the future. And then we always have as our North Star equal access. Equal access, which meant, for me, language access. It meant ensuring that our most vulnerable communities could be present. It meant fines and fees and who's keeping people out and why are people afraid to come to court. So we created Access 3D, and I learned of that idea because I was watching some three-dimensional cartoon with my children, and I thought, everything is 3D nowadays. Access to justice could be 3D. But it was a prism for how we thought about all the ideas that came into the branch from all of our new stakeholders, the lawyers and the different bar associations and the age groups. So I'm proud that together we worked on controversial issues like language access, not only in the courts, but also at the counters for criminal and civil. We worked on education to better talk about the branch. We worked on funding, and we equally distributed it so all courts could be equal in how they served their counties. We talked about bail, we talked about taboo subjects, but we talked about them, we debated them, and then we came up with a report without any one full set of ideas. We didn't come to a conclusion at the beginning, we came to a conclusion at the end. So I'm grateful for all of our initiatives, which I think transformed the branch in many ways and made it more accessible, a people's court, and that we did it together. We really did it together, and I think that that's something I learned here at King Hall. We do things together, and we do it better when we do it together.
It's wonderful. And can you tell us why you decided to retire from the court?
Oh, that was not an easy decision. And I have to say that, justices are elected for a 12-year term. And 12 years goes by really fast, believe it or not. And so when my new term came up, I started thinking about the past, and I had to make a decision about filing papers. And it's a retention election, so I knew that no one could run against me, but I also thought about the future in 12 years and what 12 years means. And I know myself, if there was a crisis, I couldn't leave after 3, I'd have to see it through. And I also thought, how many years have I already served? Well, 32 years I've already served. And it didn't feel like 32 years, but did I want to do another 12, or what portion of it? So if I were to leave, it would be at this juncture. And if I were to leave, what would the branch look like upon leaving it? And we had the best, highest budget for the judiciary that we've ever had in the history of California. Courts were well funded. We had a language access plan in place. We were known for fine and fee reductions. We had survived COVID, come up with new rules, remote access. We were in a great place. And now, having worked with so many stakeholders like I just described, I felt that even if I left, the branch would march on, because we now sort of have a new DNA about who we are, and that we are truly a third co-equal branch of government, and we take initiatives upon ourselves, we study them. So it just seemed if I were to go, this would be the best time. And so as I was contemplating this, I understood that the president and CEO of the Public Policy Institute of California was leaving. And I'd always thought that was a dream job. You know, I'd sit with friends and we'd say, what would be your job if you weren't a lawyer, a teacher, an executive? And I'd say, well, I want Mark Baldessari's job. And then we'd laugh because we thought, Mark Baldessari has the best job in the world. He'll never leave the Public Policy Institute. And now he was leaving. And so it was really like I had a month to decide. Be open for consideration for PPIC or file my papers. And I knew I couldn't do both. That true as law is a jealous mistress. You can't serve two masters. So I decided I would try for PPIC, and lo and behold, I ended up going to PPIC.
That's great. So you came up through the ranks in both your education and career. You attended public high school, as Dean Johnson mentioned, at McClatchy in Sacramento, went to community college and UC Davis for undergraduate and law school, and you served on the municipal, superior, and appellate courts before the California Supreme Court. How did having hit all those steps influence your educational path?
Thank you. I will say that I learned that no one institute and no one person and no one party has a lock on good ideas. And that all of those ways, I've met so many interesting people that shared ideas and shared hardships and shared aspirations, and realized that when, in my mind, I realized we're all of us are showing up, and on this day we are doing the best we can. And on some days I'm better than others, and some days not quite so great. But it's always a chance to come back the next day and try harder and learn from each other and to empathize. So I think going up through those ranks, particularly public school, and then and working at the same time while I was going to school, is that it's a struggle. And if we can do things together, and we can do things with dignity, and we treat people with respect and kindness, because we're all in this together, it makes a huge difference on our ability to succeed and our desire to continue, to feel seen, you know, and to talk to someone to find out, wow, they are just like me or you, even if they come from an incredibly different financial situation or family situation or experiences. When you get to know people across the board in that public education system and hitting all of the different steps, it just made me appreciate that people have such great value together. And so I think that really informed how I came to King Hall, and it informed how I reached out at King Hall, and it informed my legal career as well as my judicial career.
And what role has your family played as you're going through all of this, education to career?
You know, for a lot of us, our family, our parents and our aunts and uncles and our grandparents never had a chance at education. They were never given the opportunity. It wasn't even thought about for them. It was some far off idea that one day they could go to school, or that school would be free, or that they would be accepted. And that goes for not only people of color, but females, period. So my family always saw education, as many of yours probably, as the golden ticket. That's what you need to get. But at the same time, my family didn't have any education. My father was educated up to 2nd grade and learned a skill when he lied about his age and joined the Army when Pearl Harbor hit his island, when he was living in Hawaii at the time. And my mother, as I've said before, grew up as a farm worker, so she lived field to field, crop to crop, high school to high school, and she didn't have any higher education beyond high school, except when she was 50, she went to community college with my sister. So that was a huge thing, is to get an education and to do the best you could and to get a job. But my parents never had any idea that I could aspire to anything professional. We didn't know a professional, and so we didn't know what that was. So they taught me to strive, and they taught me to continue to keep trying, and every step that I took was more than they had. So it was very inspiring. And my mother did not understand really what I did, but she kept saying, I know it's good, I can't believe you're here, I don't know what the chief does. She would meet governors, and she'd have coffee with governors and have conversations with governors, and she used to always say when we were growing up, to take a nap, she'd say, "Don't call me unless the governor calls." And he did a few times. So they were very inspiring to me to try to think that had they been given the opportunity and the chance, how far they would have gone if they had been born at a different time.
We hear a lot about people's concern about the extreme politicizing of the U.S. Supreme Court. In your experience leading the California Supreme Court, what perspective can you offer on this?
My perspective is honestly that everyone should take a deep breath and exhale. I think that as critical thinkers, all of us need to read multiple sources, including the opinion. And I know everyone here does not want someone to tell you their opinion, that you want to make your own after you've considered multiple sources and then critically think about what the facts are. It is true that the reviews of United States Supreme Court opinions are rife with positions and opinions, but you should have your own. And then at the end of the day, while you may be definitely disappointed by the direction and role the court has taken, it is the United States Supreme Court. It is our third branch. It is our top branch. And you must read and find a way to live with that and to find a way around it, to find and move. It should motivate, honestly, people to act in their state, to seek public policy changes in their state, to engage in civic engagement and civic literacy and civic education, so that you're getting an opportunity to build your own state and to have rights in your state that maybe are not going to be guaranteed constitutional rights, but you can make a difference in your state. You're being given the silver lining is you're being given the opportunity to make a difference in your state, in your locality, in your community. So, we can lament a lot of things that's happened, and it's interesting to talk about, and it's interesting to try to predict and to handicap and to watch and to read between the lines. But at the end of the day, I think what these case decisions are telling us is responsibility lies on your shoulders. And if you're going to complain about it, then you need to do something about it. And you need to do something in the arc of your career, because it is long and you can make a big difference, especially if you work collectively. So it is alarming, and decisions are surprising in their breadth. And many of us as jurists say, well, they didn't need to go that far. And all of you lawyers also read those arguments, and I know you reject some out of hand, and some of those arguments were the winning arguments. But that is the beauty of the Constitution and the Bill of Rights and the other 17 amendments, that we are still trying to figure out the First Amendment and what it means, and what the Fourth Amendment means to technology. And it's fascinating times, and you're in a fascinating place to make a difference.
Before we get to questions, which we're going to do shortly, I wanted to ask you about your experience with King Hall students. I know you've been very supportive. You were very supportive of externs coming to the Supreme Court. Can you tell us more about that?
Yes. Well, every semester I would make an effort to take 3 externs, and I think we were largely successful, and to immerse the externs in the work of the court entirely, to be in every conversation, all about the cases, the post-argument conferences, to talk to me directly, and always the externs were paired up with many of my brilliant staff, including Jake Deere, who was the law review editor when I was a student here at King Hall, and he was my top lawyer. He was a supervising attorney, the top lawyer in the California Supreme Court, and he and I retired at the same time. I think Jake might be watching, but we tried to expose the students to as much as we were seeing, and we were trying to also learn from the students. We were learning what shocks you, what do you find wrong. I would always ask in the exit interview to ask them to tell me there's something that surprised them about the court or a way we could improve. And the King Hall students were always top notch. And I'm not just talking about grades, I'm talking about their willingness to participate. If you're at the Supreme Court, there is not a right answer yet. That's why the case is at the Supreme Court. The courts of appeal have various views, there's conflict, there's great arguments out there. If we knew the right answer, we would not have accepted review. That's how it goes. So that the King Hall students we had, they were curious and interesting, and they were bold, and they stated how they felt. But it was a safe environment. We were around a table of lawyers, and there's a fair amount of joking going on and ribbing going on as there is analysis. And I always benefited from King Hall eyes and things they recommended we change. And always then too, we've stayed in touch. After graduation, as they've entered the professional field, and I'll see them at different bar functions. And always, if they're in San Francisco, they just come on up and come and see who's in, and we're always there for them, and we learn from them, because now they're practicing law directly. We haven't practiced law in decades, and we learn from them and they learn from us. And it's enriching, and all of the, I have a number of research attorneys, and all of us are engaged in their development, and all of us have been educated by them.
Well, thank you for all of your support of King Hall. And
Pleasure.
yes, I'd like to get to questions here in the audience. Yes, in the back.
I'm one of the emeriti that was not privileged to have you as a student. But I've taught many students who have judicial careers. And I wondered if you could tell the students here who might have similar aspirations, what courses at King Hall you found of special importance to your career as a judge.
Thank you. And I'm not sure it was a privilege to have me as a student, but I do appreciate your introduction. When I came to King Hall, I don't know like many of you, but certainly there was no internet. So if you didn't know a lawyer, you really weren't, as a student, understood exactly what a lawyer did. So at King Hall, I think the classes, I enjoyed all of the classes. I particularly enjoyed, of course, contracts, and I enjoyed evidence and criminal procedure. But all of the classes at King Hall taught you how to think critically. You will, of course, you take a number of classes, but the truth is when you graduate and you're practicing, you're going to have to go back to basic principles of law in that area. And you're going to have to research what has changed. So you are going to have to start over every single time you have a client and issue a case. That's your due diligence. You can't just say, oh, I remember civil procedure and I know summary judgment and I know all the standards, so I'm just going to take it from here. You've got to go back and you've read it, you know it, now you know the framework. And what I liked best about King Hall was that it truly engaged in the Socratic method. And the Socratic method, by calling on you as to what the next element was or why this element existed in all of the classes, is that, boy, you were on your toes because you were afraid you were going to be called, or because you knew that you might have to answer the next question or build upon the analysis, and because we were small enough as a class to really empathize with your friend who was suffering through that answer. So it made us all think critically. And the takeaway at King Hall is to think hard and critically, and to think broadly. And I remember at King Hall, one of the greatest things I learned in legal writing was to start at the beginning of an analysis. Go through the analysis step by step. You may think you can just jump directly to the answer, and maybe in some instances you might be able to think that, but you're going to have to start over and go through the analysis and explain it. Because if you're in court, or you're challenged by the other side, you're going to have to explain every step of that analysis to get to your conclusion. And King Hall truly engaged in the Socratic method. The list is there, and the professor would just call the name out. And so at any time you were poised to engage directly with a professor, an expert on the subject matter, and it was fearful and terrifying, and that's what made you learn. It's that heightened vigilance you have. And I understand that some schools no longer engage directly or as much in the Socratic method in the teaching process. But I think that's truly important to have, because it heightens your awareness and you remember it, and you also think about how the student answering thought about it. You learn how people think. And of course, when you practice law and you have an opposing side, you need to think how they think in the preparation of your case. Thank you for that question.
Yes. When did it first occur to you that you might become a lawyer?
Well, it occurred to me only because there was a time when in the Filipino community, my mother took me to a great big hall, and because there was a Filipina lawyer who was going to appear to the community, and we had never seen one. And my mother said, took me. She didn't take any of her other kids, she took me. And it turned out to be Gloria Ochoa Mahino, also a UC Davis graduate. And she was the first Filipino lawyer any of us had ever heard about in the Filipino community anywhere. And my mother elbowed me and said, you can do that. And I didn't know what that was. But I knew that my mother and all of these Filipino people from the community with very little education and hard workers were here to see this woman, and because she was a lawyer. And that's when the first thought of, there's something called the lawyer, and maybe I could be it. But it didn't really materialize until I went to a community college. And at the community college, I was dual enrolled, a senior in high school and going to a community college. And I joined a speech and debate team for various reasons, not for speech and debate, but that turned out to be an opportunity. And I debated against other college students, some of whom were going to law school. And so they're the ones who told me about law school. And the first and only law school I ever heard about was Southwestern. And I thought, well, what is Southwestern? And they made it sound like, oh my gosh, it's a place in Los Angeles and your dreams can come true at Southwestern. You can be a lawyer. And I thought, I'm 18 years old and I think I think I can do that because I can beat these boys at debate, so that's really when it started to form.
So that kind of emphasizes the importance of seeing someone who looks like you in a particular position for all kinds of different groups.
Thank you. I think that's right. It just means you see someone and it catches your interest, and then you hear about it and it plants a seed, and maybe later on it blossoms into something. Thank you.
So Chief, you've always, I got the impression, because I've known you for many years, been a mentor. What would you like to teach? Maybe art, maybe athletic studies, maybe law? What would you like to teach one day?
Well, that's a good question, because I would like to teach maybe trial advocacy. I loved trials. I appeared before Judge Roby numerous times as a trial attorney back in the day. He was also my boss when I went to the municipal court. But I enjoy a good structured argument, and I think that it makes you think about all angles. What I also really like, I'd like to sort of teach not only trial advocacy, but potentially what it looks like from the eyes of the trial judge who is presiding, and what the trial judge is looking for, what a good trial judge is looking for, that you should be aware while you are trying the case. I also like talking about appellate issues, brainstorming and issue spotting. So I like a number of things about it, but I think trial ad is the most fun. And even if you do not ever get into a courtroom, if you are advising a client, you're going to have to think about eventually how that might play in trial. So you have to think about those kinds of considerations, because as we know, nothing settles a case like a trial date.
Thank you for your great lecture. I am from Chile, and I have served like a justice there for 3 years in a court of appeals on patent law, which is a tough
Very
issue.
interesting.
And I have been, from time to time, right in the middle of a decision of 3 judges. And I was the brand new one that had to solve very difficult cases. So my question for you, I know it's a tough one. Our system is different because we are in the common law where the decisions are binding only for the case.
Mm.
But they are also important, but they are on the magazines and the legal community around reads what we write as a decision. But in the US it's different because I was reading about the affirmative action cases, one against UC Davis and a medicine student back in 1978. And the way they made the decision, the justice, I mean, it was really interesting to read that as the way they mix law, politics, individual views, and the like. How is to be that deciding judge that has to make a fundamental decision that will last for many years? Did you play that role of making the decision being like the deciding judge?
Thank you. Well, of course, on courts of appeal and courts of review, most often it is a plural panel that reviews the work of the trial court. And it's always a panel of an odd number. So it always contemplates the possibility that there will be a split decision and a majority decision and a dissenting decision. And that is, I think, incredibly valuable because in dissents as well as concurrences separate from the majority opinion, what you read is how the jurists are thinking about the issue, which means that for future cases, the parties have an opportunity to read that and think about what the justices might want to see in the future, or how they could potentially view an issue in the future. So it is a little discomforting to be the swing vote, to see two positions. And always at the Supreme Court and the Court of Appeal, the decisions are always, I want to say, nuanced in that they're not unreasonable. My colleagues are not unreasonable. I just don't, there's a point sometimes in the analysis, I do not follow it. I do not agree with it. And so, you know, we agree on the facts. We agree what the law is most of the time. And then it is in the application of it where we see our differences. And it's very difficult to be that person who decides which of the opinions will be the majority or which will be the dissent. But at the same time, when you engage in the critical thinking, when you form your own opinion, when you do your own research, when you stay within the parameters of the ethics of the resources of the case that you can look at, the evidence, the arguments made, the case law, you are duty bound by oath to decide that opinion for yourself. And your colleagues, I think, understand that because they've engaged in the same rigorous analysis where they landed where they did. And so in my experience in California, as long as my colleagues understand and I am respectful of their opinion, and I've explained why I differ, and it's not ad hominem, and it is a respectful discussion where we differ on the law, then that's fine. And that actually, I think, advances the law. Many times we have said a dissent in an old Supreme Court case years later can become the majority. And it is reading those dissents and taking that dissent even a little farther in the right factual circumstance that builds the law or clarifies the law. So I think in many instances also for the public that reads our cases, I think it's healthy that they see we don't always agree. And if they take the time to read our opinion, they know why we don't agree. And they also know that it's forthright, and it's not for a political reason. It's not because I'm no party preference and he's a Democrat. That has nothing to do with the analysis. But sometimes those are the kinds of reasons that are given by the press for why a decision has come down the way it has. So I think it's uncomfortable. We'd all like to be kumbaya, always in agreement. But the whole purpose of the appellate process with 3 jurists with their own chambers is to provide multi-faceted views of the issue.
Thank you so much.
Time for our last question, yes.
So in your current position with the PPIC, how do you decide what issues are going to be researched and reported on, and how do you see that really making an impact under what's now your team?
Thank you. Well, here's At PPIC, it divides itself into different areas of focus: criminal justice, water, land, and air, K through 12 higher ed. And in those different focuses, there are researchers, PhDs and masters and fellows, who will eventually write and research with help and input from external sources to keep it nonpartisan and data-driven. And so what we at PPIC try to do is, with our different advisory groups, so we have advisory groups that are attached to, say, criminal justice. That advisory group is both DA, defense, and victims groups, and they advise on the hot topics, the issues that are being debated now that could form a policy later in the legislature in this year or the next year. So PPIC tries to get ahead of it in order to provide that information so that it informs the policy or the development of the law in the legislature. So I regularly go to the legislature now, and since I'm not asking for money, they're so happy to see me. And I ask them what their interest is and what they'd like to see, and they share about what their concern. I'm going to write, they're worried about higher education, declining enrollment. And we have a unit that studies that and surveys that. So we're trying to glean, well, if the legislator, if she has an issue there, we know she's going to look to develop law. We're going to get ahead of that, and we're going to do the research, and we'll contact her staff and leave our cards and say, look, we're going to have a fact sheet out on this. We're about to do the survey. Do you have some questions you want included in the survey for this legislation to further this policy? So we're trying to work a little bit ahead of the issue, but also trying to glean what it is the member needs. And we're a resource, and we're giving our research away, not only in reports, but in blogs and tweets and videos and fact sheets and explainers and summaries in the easiest digestible way, so that they can go deep, or they can read it and say, oh, not a problem evidently, and move on.
Great. I'd like to invite Dean Johnson back to the podium.
Let's give the Chief Justice a round of applause. Quite tentative, well, very carefully. As the Chief mentioned her teaching interest, and I took some notes. You might want to vendor over there, so I will be in contact with you. But before we go to lunch, I wanted to present you with the UC Davis Law Leadership Award for Excellence for all your great work in public service and law.